This week we will be spending our time deconstructing legal analysis. Let's begin. When we think about legal analysis, more than likely you've had an opportunity to sit in a law school class. And legal analysis is oftentimes taught through the Socratic method. This idea of what if X or what if Y, which forces students and practitioners of the law to really think about what from a legal perspective the case is trying to get to, and if there were facts or policy circumstances that changed, would we still get the same result? So the Socratic method is a useful tool, but why do law schools still use it? We know by now that oftentimes when we read a case, there is not one correct answer, and oftentimes there is no clear answer at all. So the primary goal of the Socratic method is to not answer those unanswerable questions, but it really is to explore the contours of often difficult legal issues and to teach students the critical thinking skills they need to analyze legal issues. How is the Socratic method then used? Well, it is done oftentimes by altering the facts of a particular case to see how the result might be different if the facts changed in one way or the other. And the Socratic method really encourages students to go then beyond simply memorizing the facts of a case and to really focus on application of the legal rule that you can identify in the case and apply that to varying fact patterns. So let's take Pearson versus Post as a way to walk through various hypotheticals, knowing the rule of Pearson versus Post and then applying them to these varying fact patterns. So in Pearson versus Post, we know we have a three-part rule, that to establish occupancy we must show intention of taking the animal for individual use, depriving the animal of its natural liberty, and that we must bring the animal within certain control. So again, a three-part rule. We have to show intention, depriving the animal of natural liberty, and we must bring the animal within certain control. So we see on the slide here that we have hypothetical number 1. Here we have the same facts as Pearson versus Post, except in this case Obama shoots and captures the fox before Cheney captures or kills the fox. What do you think? Same case or different? And likely you identify that the only thing really changing here is that the parties are different in terms of name. There isn't anything else from a legal perspective that has changed in the hypothetical, so it's the same case. And hypothetical number 2. Say here you are in pursuit of a fox on your property. Wendell comes onto your property and shoots and kills the fox right before you can get to it. Is it the same case or a different case? Here we have a public policy issue, so it's a little hard to know whether or not the courts would treat this case similarly or different from Pearson versus Post. So what would likely happen is that the rule of Pearson versus Post would be taken, applied to the facts in the previous case, and then the court would need to decide which rule would be better in this situation. And there are 2 examples on the slide. That possible rule number 1 is one that allows hunters in hot pursuit of a wild animal to go onto the private property of another. And possible rule number 2 would be a rule that discourages hunters from going onto the private property of another, even if they were in pursuit of a wild animal. So here the question really becomes, does the public policy of maximizing the kill of wild animals outweigh the public policy of protecting property rights? And if you say no, then in hypothetical number 2, you would get to keep the fox, even though Wendell killed it, because Wendell trespassed in order to access the fox. So it's clear here that if you were in a course, you would be articulating what options the judges had, that they would be able to utilize public policy to come out with one decision versus another decision based on answering the issue that has been presented in the hypothetical. Next up is hypothetical 3. Here we have the same facts as Pearson, but this time the fox becomes exhausted and falls over on the beach. Before Post can get to it, Pearson walks over and grabs the fox. Do we have the same case or a different case. So here, would you say that post has a stronger argument or a weaker argument in this case as compared to the original case? Maybe we have a gray area. Again, in hypothetical 3, it was the same facts as Pearson versus Post, but this time the fox became exhausted and fell over on the beach. So before Post could get over to it, Pearson walked over and grabbed the fox. So you would take the rule, the intention, deprivation, and certain control rule, apply it to the hypothetical, and see what you come up with. Here we have hypothetical number 4. And here, Post was driving down the street and hit the fox. He heard the thud, but kept driving. So Pearson walked down the street, saw the fox, and picked it up because the fur was valuable. Post learned of the value later and sued Pearson to get the fox or the money. Who would prevail in this case after you apply the rule to these facts? Again, you would apply the rule of occupancy and its elements. So as we know, occupance requires intent, deprivation, and certain control. Based on what you know and the application of the rule to the facts in the hypothetical number 4, what would you argue? So although you may not have gotten your answers as to which facts were similar to Pearson versus Post and which were different, the key is feeling comfortable with knowing that there may be gray areas and that you may have to not have a final answer, that instead you have an opportunity to legally analyze the facts, the rule to the facts, and then being able to articulate your point. So a frustrating process indeed, but the what-if game, the Socratic method, is really important in the law school experience because it tests your knowledge and understanding of the rule that you just learned in the case in question. You can't get that type of practice anywhere else if you simply memorize the rule. It also tests to see if you recognize the new fact pattern as factually distinct. It forces consideration about new public policy assessments, and it forces all of us to consider whether the prevailing rule is the proper rule or whether the court should adopt a new rule. This opportunity to practice legal analysis is really key as law students or graduate students. And so we'll continue to practice by looking a little bit deeper as to what Wendell meant by introspective legal analysis. And what do you think it is that he means there? So within the chapter, as you read it, you will see that introspective legal analysis means that for every rule analysis, there is usually additional legal analysis necessary within the rule, or rule elaboration, which we spent some time on in previous weeks. So rule elaboration is introspective in that a court takes a single rule and breaks down the rule into its various elements, creating rule elaboration for one or more elements of the rule. On the other hand, case synthesis is extrospective. This is where a court takes several cases or rules that individually do not apply to the case before the court, but the court analyzes the cases collectively and in relation to each other to see if there is some sort of overarching public policy consideration and whether or not a new legal standard should connect the cases, thus forcing the adoption of a new rule of law for the case pending before the court. Here you can see the differences between a conceptual statement of a rule and a doctrinal statement of a rule. So from a conceptual basis, you can understand what the rule generally does, the general effect of the rule, and offer some statements about a rule. But a doctrinal statement is the rule statement itself. It's the various elements that must be satisfied for the rule to apply, and the rule sentence. So let's look at a few examples. You can see on the slide the differences between conceptual statements and doctrinal statements, and we're using adverse possession here to illustrate the point. So we know from a conceptual statement of a rule that what's on the left side of the screen should identify what the rule does, what adverse possession is. the effect of the rule, and provide generally a statement about the rule. So you can see that here, where it notes basically, if one takes possession of another's land and uses the land in a way that satisfies the requirements of the rule, the law automatically transfers title from the original owner to the adverse possessor. So you can take that and compare it to the doctrinal statement of adverse possession. And we know that doctrinal statements are to provide the rule statement itself, the elements that must be satisfied for the rule to apply, and a rule sort of sentence. And here you have that. You have adverse possession requires, number 1, actual entry onto the land that gives rise to possession. Number 2, must be open and notorious. Number 3, must be exclusive. Number 4, it must be adverse or hostile. Number 5, under a claim of right. And finally, number 6, continuous for the statutory period. Let's look a little bit deeper at Howard versus Kunto, which actually is an adverse possession case that was assigned in your reading. So let's look at the case. What was the question of law on appeal in Howard versus Kunto? And we know from reading the case that the question is, what constitutes continuous possession for purposes of adverse possession? And we know that continuous possession is generally an element that must be met in an adverse possession context. So here, continuous possession is an element of the rule, and the court needed to provide a rule elaboration for the element. In essence, the court was asked to create a subrule for the element. In the Howard case, why do you think the court adopted a different meaning from the ordinary dictionary meaning for continuous and uninterrupted? As you saw in the case, the court noted that the dictionary definition did not match with other legal writings at the time. So it's important to not just look at the legal dictionary or the legal definition of words in order to come up with what should be applied in a particular case or factual situation. So the idea is to really be aware of concepts of legal meaning, legal significance, legal definitions, terms of art, and really how the role of public policy in specific contexts may change or create legal meaning or significance. We have discussed this previously, but it's key to continue to return to what is proper application and analysis of a rule. And we know that in order to properly apply rules, you must break the rule into its elements, and then must apply and analyze each element to the facts presented. So applying and analyzing each element implicitly means that each element becomes its own issue, often with its own rule elaboration and subrule. So it takes a lot of work to apply introspective legal analysis. Here is an example that might make that a bit more clear. Say you have a global issue. So what is adverse possession? And the global rule may be the 6 elements related to that. Your sub-issue 1 may be on one of those elements. In the Howard case, continuous was the issue that was being presented. And the sub-rule 1 will require you to analyze the issue. And so on and so forth, all the way through an appropriate legal analysis. So it's really important to simply identify the issue, identify the rule. If the case has multiple elements, you would need to conduct an IRAC analysis for each element presented in the rule. So again, really hard work. It takes a lot of practice. What happens a majority of the time is because it takes a lot of practice, and it takes a lot of time to do this deep legal thinking, that it's easier simply to provide conclusions about whether or not various elements of a rule were met. So it's really key that when you walk away from this class, that in your legal analysis you are not making conclusory arguments, because conclusory arguments draw irrelevant conclusions. They lack oftentimes a rule or the factual support necessary to reach the asserted conclusion. Conclusory arguments are logical fallacies. Thus, they omit a premise, they substitute a major premise for a conclusion, etc. So conclusory arguments are a no-no, and let's walk through what they may look like so that you can beware. Returning back to the Howard case, here is an example of a conclusory argument. So here you could say the open and notorious element of adverse possession requires visual evidence of possession that is sufficient to put a true owner on notice of the adverse possessor's presence on his land. Fences, plants, and improvements to the land are the kinds of evidence courts have typically looked to. Here, T claims she was on the land for 10 years, thus the owner probably should have been on notice. Conclusory. And what you'll see here is the conclusory argument fixed. You'll notice that much of what is included was actually included on the prior slide, but here you have additional details, and it's the details that is really the key. So let me read this. The open and notorious element of adverse possession requires visual evidence of possession that is sufficient to put a true owner on notice of the adverse possessor's presence on his land. Fences, plants, and improvements to the land are the kinds of evidence courts have typically looked to. That's the rule. The second bullet point says here we know T built a shed, installed a fence, and planted a flower garden that was visible from the street. That's rule application, so we've taken the rule, applied the facts in the case, and then the conclusion. Because the improvements are the kinds of improvements courts have typically looked to, so we're referring back to legal authority, and because any owner seeing these improvements on his land would have noticed T's presence, the owner probably should have been on notice, and the open and notorious element is likely met. And that's the key, right? We're returning back to the legal rule that is identified in the first paragraph. So let's look a little bit deeper. Over the next couple of slides, compare the various arguments. So you'll see on the left side the conclusory argument, and on the right side the more detailed analytical argument for open and notorious element of adverse possession. The key really here, again, is that the details is on the right-hand side of the screen. And here we have the actual application of the facts to the rule. So on the left side are these various things that courts could look to, and on the right side, here we know that T built a shed, installed a fence, etc. So there's the application of the facts here, which is really important. And here you can see the differences in the conclusion, where on the left side you have a very clear conclusory argument. T claims she was on the land, but doesn't provide any additional detail, and the owner probably should have been on notice, so no additional detail. And on the right you can see all of the various ways we discussed improvements, what the owner should have seen, that the owner should have been on notice, that the open and notorious element is likely met, etc., etc. So the details, again, are really, really key. Let's practice just a little bit more by analyzing the George in the Park hypothetical employing IRAC. So please grab the George in the Park hypothetical document and we'll go through this together. Let's look at the George in the Park hypothetical that was posted on Blackboard. And please read along with me. George, an ASU law student, has been living in an apartment near a park in Scottsdale, Arizona for the past few months. George frequently rides his bike through the park near his home and has enjoyed his bike rides on beautiful desert afternoons. Due to concerns about neighborhood noise and child safety, the city of Scottsdale recently decided that the park near George's apartment should be subject to a new ordinance, prohibiting vehicles from the park. The city of Scottsdale passed the ordinance and erected signs around the park telling citizens about the new rules. And you'll see the rule on the slide in front of you. That no vehicles are allowed in the park. Anything that moves faster than 25 miles per hour and or emits fumes or loud noises will be considered a vehicle and is prohibited. Violators will be fined. George has enjoyed riding his bike in the park for the past year. He feels that riding his bike in the park is an excellent way to blow off steam from his law studies, which he finds thoroughly invigorating if sometimes exhausting. George is nervous that if he continues to ride his bike in the park, he will be given an expensive citation. George has come to you for advice as to whether or not he should continue to ride his bike in the park. what would you tell George? The first step in any legal analysis, when you're trying to develop an IRAC response to an essay like this, is to identify the issues that were presented in the fact pattern. So look away from the slide and see if you can come up with various issues that were presented in the fact pattern. And when you're ready, come back to the slide. And here are 3 that I have identified. The first is George's bike a vehicle under the ordinance? The second, should George continue to ride his bike? And the third, does the ordinance extend to George's bicycle? So with those issues, we know what the rule is as well. That was presented in the fact pattern. So let's look at that next. The elements of the rule that are presented are broken out a little more doctrinally versus conceptually. So from a doctrinal viewpoint, a vehicle is, and there are 2 components, anything that moves faster than 25 miles per hour, and anything that emits fumes or loud noises. There are also policy considerations that were presented in the fact pattern, and that this ordinance is intended to increase child safety. So knowing what you know about the issues that are presented, you have the rule. Try to prepare an analysis applying the rule to the facts that were presented and that George is requesting your assistance with. In your legal analysis, you may want to utilize relevant facts. So maybe the types of questions that should be asked, because you aren't given a ton of information, are things like, does it matter what kind of bike George is on? Does his bicycle emit fumes or make noise? Can George, when he's riding his bicycle, travel at more than 25 miles an hour? And are bicycles threatening to child safety? And these types of facts are what must be included in your legal analysis, so each of these things should be a consideration included. And after you complete your legal analysis, and again, I encourage you to practice as much as you can, here is an example of one type of conclusion that could be presented, the C in the IRAC. Although it would be helpful to have more information because most bikes travel less than 25 miles per hour and are not dangerous to children, it is likely that George's bike is not a vehicle under the ordinance and may be permitted in the park. So again, very important practice opportunity for you to take the hypo or take the fact pattern that George has presented, walk through and outline the issues, the rule, write your legal analysis, and then have some sort of conclusion similar to this or otherwise. The goal in the conclusion isn't necessarily that you come to one answer, but really that you've walked through and have supported your conclusion based on your legal analysis. Deconstructing legal analysis is hard work. It forces you to think outside of the box. It forces you to go beyond memorizing a specific rule. And it forces you to really look at different facts or policy considerations that a court may need to consider in developing a legal rule. So continue to practice, continue to read your cases with a curious mind, and start now writing down different things that you see in the cases. Are there different issues that have popped up as you're reading them? Are you able to develop the rule and the rule elaboration into its various elements? Are you able to take different fact patterns or think about, I wonder if I change the case this way, the rule would still apply? And keep practicing IRAC analysis. It's very, very important for your success as a law student, as a graduate student, and beyond. So I hope you have a wonderful day. Continue practicing deconstructing legal analysis.